Hey everyone, my name is Nate Charles. I am the owner and managing partner of Charles Legal Services. This is the first of hopefully a long string of videos where we give you guys some entertainment and some education in various legal and security related topics. And today we're going to start out with something very basic. We're going to talk about how to choose the right lawyer. This is a very important topic. If something's happened to you and you think you need to retain an attorney to help you deal with it, we want to give you a little bit of guidance on how to go about that. So this is how to choose the right lawyer for you. And we're emphasizing the words for you because the lawyer that worked really well for your friend may not be the lawyer that works really well for you. It's really unique to you, your personality, and a host of other factors that we're going to get into. Also, the case that or the lawyer that you used in the past for another case, say your divorce lawyer, if you've ever unfortunately been involved in a divorce, may not be the lawyer that you need going forward with like a civil litigation matter. They may not necessarily be one and the same. So just keep in mind, the person that your friend worked with may not be the one for you, and the person that you've worked with in the past may not be your lawyer for the next case that comes down the road. Now, there are a host of criteria that go into choosing the right lawyer, but we think that these three are the most important. One is price, two is knowledge and expertise, and three is the temperament of that lawyer. And those even within those topics, there's a variety of sort of sub criteria, subtopics that we're going to talk about in this video that are very important and things that you need to keep in mind when you're choosing the right lawyer. So we're going to start with price. Now, there's no question about it. Lawyers are expensive. It's supply and demand. Most of the attorneys that you are probably reaching out to for help with a particular case are getting peppered with far more requests for assistance than they're going to be able to service, or at least service competently. Don't be surprised if a lot of attorneys just never get back to you. It's not personal. It's that they are trying to do their best to service all the clients that they've already signed and take on new cases as they can. But because their services are in such high demand, that the price goes up. And that's why a lot of lawyers are very, very expensive. But even if attorneys are expensive, that doesn't mean that you shouldn't be getting good return on your investment. And so we want to give you some advice that's going to help you get the most out of the resources you have available, get you the best legal services available for your budget. And that some of the nuance in that gets into the attorney billing models, which we're going to talk about here in a bit. We're going to talk about the distinction between retainers and trust deposits. And then we're going to talk about a relatively new topic. It's full scope versus limited scope representation, which may be a key to the future of legal services and providing good legal services to people who can't necessarily afford a full-time, full-scope attorney. We'll get into that in just a few minutes. Now, there are a variety of different ways that your attorney can bill you for his or her services. And these are things that you can negotiate. There's things, and you should negotiate these with your attorney. You should have a full understanding of how it is that your attorney is going to make the money that you're giving him or her right up front. Now, the most traditional one is an hourly rate. Um, Hourly rates can be anything from $50 an hour all the way up to thousands of dollars an hour, depending on your location, the type of case, and the skills and abilities of that attorney. Um, Clients typically hate the hourly rate because when you say, "Oh, well, I'll do my services for $500 an hour," and they say, "Well, how long will it take you to do what you need to do?" And sometimes the answer is, "We don't know." It depends on the complexity of your case. It depends on how litigious the other side might be, and frankly, if you pay an attorney based on an hourly rate, and you've got a very contentious case, your bills can go up pretty dramatically. It can also go up pretty dramatically if there are unusual cases or unusual facts in your case or unusual legal issues at issue in your case. Those things can all drive up research time and costs quite a bit. The second model is a flat rate. Uh, Clients tend to drastically prefer flat rates just because they know right up front what they're going to be paying for your services. And this is generally like if you've got a DUI, flat rate is pretty typical in a DUI scenario. An attorney right up front might say, hey, I'll handle your I'll handle your DUI for $15,000. And again, that figure can vary widely, but they have a good idea up front of what kind of work is going to go into defending you from that DUI. They may have a good relationship with the district attorney's office already. They know who to talk to. And so it's easy for them to predict what they're going to have to do and, to defend you from that case, or and not just DUIs. There's a variety of other types of cases that may involve a flat rate, and they will tell you right up front how much they think they're going to charge you, and it's much better for the client because the client knows right up front what it is they're going to be paying. Um, Fee for service is a little bit different. Fee for service is sort of a model where um, the client will pay for particular steps in the litigation. They will pay a certain amount for filing a complaint. They'll pay a certain amount for the attorney to show up and take a deposition. They'll pay a certain amount. It's kind of it's a little bit of a split between an hourly rate and a flat rate. It kind of compromises between the interests of the client and the attorney. Fee for service, or what you might call a la carte legal services, or something that are probably going to become more popular in the future. And then there's a hybrid model. There's a hybrid model where there are certain things that the attorney might get paid for by the hour, like phone calls with you, showing up at court appearances. Those things might be by the hour, but they're willing to draft a complaint or draft up a legal document, some other type of legal document at a fixed rate. And that, in some ways, again, mitigates the various risks that are in place for both the client and the attorney. And then there's this thing called a contingency fee, which is sort of unique. This is what most plaintiffs' attorneys do. These are like your slip and fall attorneys, your personal injury attorneys. They tend to use contingency fees. If you've ever seen a commercial where they say, there's no money unless you win. No, you don't have to pay anything unless you win. What that attorney is talking about in his advertisement is a contingency. And again, this is usually where a client comes into an attorney's office and has a particular cause of action, something that was done wrong to them. And the attorney can estimate roughly, what that person's injury or what that person's damages are going to be at the beginning. And they say it's typically 1/3, 33.33%. They'll say to the client, look, we can sue these people, and whatever you recover as a result of the lawsuit, I'm going to take 1/3 of it. You take 2/3 of it. You get some justice and I get paid. And that is a perfectly acceptable model that's permitted under the rules of professional conduct. Now, the term retainer is maybe one of the most misused terms in the legal profession. Um, at its most technical use, the term retainer actually applies to something that a potential client pays a lawyer up front just to be available in case something happens. It's almost like an option. It's like paying that attorney up front to drop everything in case a certain thing goes wrong for that client. And that attorney will show up, wherever that client happens to be, and will put their case ahead of all the things that attorney's got going on. Frequently, the term retainer is used in place of what should be more properly described as a trust deposit. And a trust deposit is when you pay money up front at the beginning of a case, and the attorney bills basically your trust account for the services that he's providing. The reason that attorneys do that is because there is nothing that they can use otherwise to secure their work. Now, if they do, $10,000 worth of work for you, and then you just walk out on their bill, there's not a ton that attorney can do to get that money from you except sue you, which attorneys really don't like to do. They don't like suing their own clients. It's just bad for business. So what we do to try and avoid that is we collect trust deposits from our clients up front. The client will put money into a trust account that we have to maintain in good faith. It's still the client's money. It is still the client's money sitting in that trust account, but it's something that's under the control of the attorney to make sure that nobody goes running out on their bill, much like somebody might run out on a check at a restaurant. That's the purpose of a trust deposit. It's just paying the money up front, but it is still your money, and any money that the attorney does not earn over the course of your representation, he has to give it, or she has to give it back to you after the case is concluded. That's the distinction between a retainer and a trust deposit. They're both, retainers are pure retainers. Actual retainers are not all that common. Trust deposits are very common. although they are frequently mislabeled retainers. And there is a very important purpose behind them. It's not something that the attorney is doing to punish you. Now, there's this movement towards limited scope representation in the legal community, and I encourage this. This is a good thing. Full scope representation is sort of the traditional approach. It's when you hire a lawyer and your lawyer is responsible for everything in that case. Your lawyer is responsible for keeping you informed about everything that's going on. Your lawyer is responsible for spotting all the issues in your case. Your lawyer is responsible for showing up in your place when you have to go to court. Even though in some cases you will have to be there, but your attorney can actually waive your presence in some instances. And I think most importantly, your attorney is the point of contact for communications with the court. So when the lawyer sends you a document, they're not sending it to your house; they're sending it to your lawyer's office, and then your lawyer is responsible for informing you what's going on. Limited scope representation is sort of a modern approach, and this required some adjustment to the rules of professional conduct in a lot of states. But it's a good thing because it actually allows people to get access to legal services who otherwise might not be able to afford full scope representation. Now, limited scope representation is pretty much the way it sounds. It's when a lawyer shows up, but only shows up for certain portions of your case. You, as the client, will represent yourself on most of it. But there are certain things, obviously, where you're going to need advice. There are certain times where you're going to need some expertise in preparing perhaps a legal filing. It's people don't feel comfortable doing those things themselves, and that's totally understandable. You're going to need a lawyer to do some of those things for you. So you hire a lawyer just to do those things. Generally, the billing and limited scope representation is kind of like that a la carte, that fee for service model that we talked about just a few minutes ago. You pay the lawyer just for the work that they're doing, and it ends up being far fewer fees that you're paying to the lawyer over the course of your case. But it does also require you to do a lot of the work yourself. These are good for people who are comfortable with DIY projects. They may be interested in limited scope representation. Okay, knowledge and expertise. Now, obviously, everybody wants the best quality product that they can get for their money. That's axiomatic. But there is some nuance to knowledge and expertise, especially when it comes to choosing a lawyer. Everybody is going to say, "I want the best possible lawyer." Well, the reality is, you probably can't afford the best possible lawyer, and the other reality is, you probably don't need the best possible lawyer. And we're going to get into some nuances there, especially in the distinction between specialists and generalists. Now, there are a few things to consider when you're weighing the knowledge and expertise of a lawyer thinking about hiring. Are they a member of the bar in the place where your case is being litigated? Are they admitted to the courts that are going to be handling your case? How important is knowledge and experience, especially in your particular case? And then I want to have a quick conversation about specialists versus generalists. Now, bar membership is maybe the most fundamental and basic of these concepts. A lawyer can only practice where they are licensed. And not only are they not permitted to serve as an attorney, they may actually be committing a crime, unlicensed practice of law, or at a minimum, a violation of the rules of professional conduct in the states where they are licensed. I am a Pennsylvania attorney. I'm a Maryland attorney, and I'm an Alaska attorney. I'm allowed to show up in any of the state courts in those states and represent clients. If you have a problem in a state court in California, I cannot show up and help you with that. I'm legally not permitted to do that. Even if I know the law in that state, I'm not allowed to show up on your behalf. And I could very easily get myself in trouble giving you advice if I'm talking out of turn, if that advice relates to a legal issue in a state where I am not licensed. This is very important. You have to make sure that your attorney is licensed where your case is going on. Now, similar to the issue of bar membership, there is also admission to various courts. There are, in every state of the union, there are federal courts and there are state courts. And just because an attorney is licensed in the state courts does not necessarily mean that he is admitted to the federal bar in that state. I am admitted to the federal bar in Maryland. If you have trouble in Maryland, I can help you in state court. I can help you in the federal courts. I am barred in Pennsylvania, but I am not admitted to any of the federal courts in Pennsylvania. I don't live in Pennsylvania. I have fewer Pennsylvania cases. Those are the kinds of things you need to take into account. Just because your lawyer is practicing in your particular state You may have a legal issue that is under the jurisdiction of the federal courts and only the federal courts, and you have to make sure that the attorney you hire is admitted to the federal courts if that is where your case is going to be adjudicated. So keep that in mind and ask those questions of any attorney that you may be considering hiring. Now, it goes without saying that you want your attorney to be sufficiently experienced to handle your matter. In fact, under the ABA model rules, Rule 1.1, the very first one, an attorney can't take a case in which he or she is not competent. But a very basic case may not require somebody with 35 years of experience. And frankly, an attorney with 35 or 50 years of experience is probably going to charge a lot more than an attorney that's got, say, 10 years of experience or even less than that. Again, those model rules are there to protect you. The attorney will not take a case that they are not competent to handle. But you can also expect to pay a lot more for an attorney that has a lot of experience, especially if that attorney considers himself to be a specialist in that particular area where they are helping you. We're going to get to that in just a second. Now, if you have a very complex case or you have a case that involves very arcane legal issues, you might need somebody with a lot of experience, and you might need somebody who actually specializes in that particular area of the law. Okay. Now, the trouble with working with specialists is if you have issues that cut across a variety of different legal disciplines, that specialist may not be qualified to handle something else going on in your life. Now, your divorce attorney who might be helping you with your $1 million divorce may be great, but if all of a sudden you get pulled over for a DUI because you were out at the bar sort of drowning your sorrows about your divorce, and you get pulled over by the cops and get a DUI, that specialist may not necessarily be able to represent you in the criminal case because they may not have the background to do that. Okay. Similarly with generalists, and I very much consider myself a generalist. I am a multidisciplinary attorney. My goal as an attorney is to be competent in a wide variety of areas so that I can take a client that comes through my door and help them with all of the problems in their life. However, if I have a client who has a very arcane and very specific legal issue that is not well understood by me as a generalist or by the courts, I may have to get that client to hire a second attorney to represent them on this very specific, specialized legal issue. So specialists attorneys are not inherently better than generalist attorneys. Generalist attorneys are not specifically better than specialists. They're just sort of two different approaches. The other thing you need to know about specializing under the law is it's different than, say, a specialist in the medical community. All right, a doctor who is a specialist has been through a residency. They've been through specific training and specific tests to ensure that they are very good in that specialty. Right. In the legal community, we don't do that. Specialists in the legal community are people who have self-specialized. They are people who just have a particular interest in an area of the law. They take just those cases. And frankly, there are some economic reasons for them doing that as well. If an attorney has all the tools and all the forms in hand for a particular type of case, they may take only that type of case because they can do those cases very quickly. They can run their clients through sort of an assembly line sort of process and get a lot of people through the door and then back out the back door of their office very, very quickly, and they make more money doing that. Generalists in the legal community actually tend to make a little bit less money because there's a little bit more effort that goes into representing people in a variety of different disciplines, but at the same time, a single attorney may be able to help one client with a variety of problems in their lives. And the last broad topic that goes into choosing a good attorney is that attorney's temperament. And this is actually a slightly more nuanced issue than you might imagine. Now, the most obvious issue with regard to measuring the temperament of an attorney is this attorney right for me? Is this attorney right for me as a client? Do the attorney and the client get along? And are they able to work well together? But there's another aspect of temperament, and that is that attorney's ability to balance attorney roles. I'll talk about that in just a minute. Now, there are some very obvious aspects to compatibility. Does this attorney seem to care about your case? Does this attorney seem to care about you as a person? But there are some other things that make a big difference with regard to compatibility, and sometimes these things don't really rear their ugly heads until well into the representation, but they're important, and you should consider them up front. There are some attorneys who are very tech forward. They love technology. I consider myself to be one of them. They love email. They will send you text messages. They will ask you to sign things electronically. There are a lot of clients, especially a lot of older clients, who are really uncomfortable with that. And so I have had clients that I have actually turned away because they were just unwilling to work with the technology that I use in my practice to make my practice more efficient. And that's not necessarily anything wrong with them, and that's not anything wrong with me. It's just not a compatible. It's a compatibility issue. They need to find a more old school attorney who is going to sit down with them around a table and hash things out, and write things out longhand and have them sign paper documents, and that's totally fine. It's just a different approach to their practice, right? The other thing is FaceTime. Especially post COVID, there are a lot of attorneys who don't even have a physical office. They do everything virtually. They hold meetings over Zoom. They use electronic documents signing technology, and again, a variety of electronic communications means. There are some clients, especially if there's a language barrier, who insist on sitting, face to face with their attorney, and that again, that's totally fine. But those attorneys are actually becoming fewer and far further between because attorneys spend a lot of money on commercial real estate to keep an office. And a lot of those attorneys are finding that they're not even using their office very much. They are working from home. They're working remotely. And so that there are actually fewer and fewer law offices that you can just walk into. Those attorneys still exist. It's just that they are leveraging technology. If you are an old school person or you've got a language barrier issue and you need to get face to face with your attorney and work in a more traditional office setting, you may have to dig a little deeper to go find an attorney that's still doing that. And finally, there's a conversation we need to have about balancing attorney roles. Now, when you hire a lawyer, you're actually hiring a person to do two different jobs. That you're hiring them to be a counselor and you're hiring them to be an advocate. And those things are not necessarily the same. And in some cases, they even conflict. Great attorneys are attorneys that are able to balance these two roles and flip back and forth between them very efficiently. And here's the dirty secret about the legal community. They don't teach that in law school. It's something that comes with experience. Some people who have really great people skills are able to do this very efficiently, and some attorneys are really bad at this. And so this is something that you need to look out for in selecting an attorney. Okay. Now, all of the activities that your attorney is doing when they're having a conversation with you, that is generally going to fall into the counseling category of activity. That is them performing their role as a counselor. Okay. Now, counseling can be, they can be, a shoulder to cry on to some degree. They're not a therapist. Most attorneys are not therapists, and are way more expensive than therapists. So don't attempt to use your attorney as a therapist. But they are there for you to vent to. They are there to listen to your case and there to communicate with you. They are there to spot issues in the case or controversy that you find yourself in, but they're also there to sort of temper your expectations, to calibrate your expectations. That attorney, you may be mad as hell at somebody and go tell your attorney. And if your attorney says, yeah, you've got a really good reason to be upset, but it doesn't mean that you've got a legal case against these people, that attorney is doing their job. They are telling you what you can expect from your case. All right. That attorney may also be coming to you saying like, hey, the other side of this case is making a settlement offer. I know you want to take this all the way to court. You want to give everybody their day. You want your day in court. You want to embarrass this person. You want to get your pound of flesh out of them, in open court. But if a good attorney is going to evaluate a settlement offer and say, hey, look, you are not likely to get very much more than this if this goes to trial, and you're going to end up paying a lot more in fees. This might be a good, you should consider this settlement agreement. Now, you are, as the client, have the ultimate authority to make that decision. You can accept that settlement agreement or you can reject it. That is up to you. But it is your attorney's job to give you good advice and be sort of a neutral arbiter of your case, and evaluate it objectively for you when he or she, as the attorney, is talking to you as the client. Advocacy is almost the opposite. That is what the attorney is doing with vis-a-vis everybody else in the case, the courts, the opposing party in general. Okay. Advocacy is where the attorney is getting in there and that attorney is being a bulldog and dealing with the opposing party, pointing out all the weaknesses in the opposing party's case and telling the opposing party why they think that you should win, to sort of intimidate the opposing party into giving you a better settlement offer or deciding not to fight you at all. Okay. And that's also what the attorney is doing with the courts. They're presenting your case. They're making the other side look bad vis-a-vis you as the client. They're trying to make you look good vis-a-vis the opposing party. Um, that is advocacy. Now, some attorneys are great advocates and lousy counselors. Okay. And vice versa. Some attorneys are great counselors and lousy advocates. You need to be very careful if you walk into an attorney's office, though, and that attorney says, "Oh my gosh, everything that happened to you was so terrible, and we're going to go get them, and we're going to get your pound of flesh. You're going to get your day in court. I'm going to get you $1 billion settlement." You need to be very careful. Like that may be something that's great to hear in the moment, but it may not be great advice. That may be an attorney who's an excellent advocate, but is also what I like to call a cheerleader. They are just egging you on, and actually attorneys who are bad counselors can actually make your life more difficult because they are making you think that you are going to be able to get something that's not all that realistic. And because of that, you make a tactical error in your case and you may lose. So you need to keep an eye on that. Okay. If you go walk into an attorney's office and they're like, "Hey, I think you've got a case, but here are the potential weaknesses and the things you need to watch out for," that is probably a good attorney because they're giving you good advice. They're trying to be objective, or at least trying to be objective, and they're trying to give you sound legal and tactical advice. Now, again, when you're trying to hire an attorney, you need to keep in mind, and even actually throughout the entire life of your case, you need to keep in mind that this advocacy role and this counseling role can be in conflict with each other. You may see your attorney go into court and attempt to eviscerate the other side and be very aggressive and argue, very capably, be a very powerful advocate, but they may completely switch when they get you into a back room and they're trying to tell you like, "Hey, I just argued the heck out of your case for you right there." But the reality is the other side's got a point. And actually that's the mark of a great attorney. You should never see the same person in the courtroom, never see the same attorney in the courtroom than you see in his office. They should take a very different approach to how they are talking to you. Then the approach that they use to talk to you should be very different than the approach they use to talk to opposing counsel and the court. Keep that in mind. So again, we talked about three sort of broad criteria, three of the most important criteria that goes into choosing a lawyer: price, knowledge and expertise, and temperament. There are literally hundreds of other factors that go into this stuff. And we're really just scratching the surface. We're just looking at the tip of the iceberg. But we do think that these are the most important criteria that go into choosing an attorney. Again, this is how to choose the right lawyer for you. I am Nathan Charles, the owner and managing partner of Charles Legal Services. We hope that you've enjoyed this instruction. You find it entertaining and valuable information to go forward with in your own case. So again, my name is Nathan Charles. I'm the owner and managing partner of Charles Legal Services. If you live in Pennsylvania or Maryland or have a Pennsylvania, Maryland case and need to retain an attorney, by all means, reach out to us, 717-202-9407, or you can send an email directly to me at nate@charleslegalandsecurity.com. If you have any questions about our firm or want to schedule an appointment, you can go to our website at www.charleslegalandsecurity.com. And we're looking forward to speaking with you. Just get in touch with us. We'll get you squared away. Charles Legal Services, we also do security consultations, although we do that through a partner firm. That partner firm is LexPat Global Services, lexpatglobal.com, run by my good friend and colleague, Adam Perlman. I am an ex-Navy SEAL and a former federal prosecutor. I've seen a great deal of things over the years. If your business or your government needs advice on any sort of security matter, you can always book me to do some consultations with you through LexPat Global Services. We'll be happy to come out and get you squared away. Thank you very much.